third degree felony, I'm going to set a bond of $50,000. Plus the condition of that's what I'm going to set in that one. We're going to have conditions on each of these bonds. $25,000 on the second bond.
Welcome back to Courtroom Chronicles. Today's case is a heavy one. A young man facing not one, but two serious indictments: retaliation against a police officer and illegal possession of hydrocodone near a playground. That combination alone sets the stage for high-stakes drama. Let's break down what really happened and what's at risk here.
Daniel Lee Harvey Jr., please.
He's in custody, Judge.
I was looking out in the audience. Okay. Two cases are called 24 CR 1041. And this is obstruction of retaliation. And it was an indictment handed up on May 8th of last year. And in summary, it states that on or about March 30th, 2024 in Jefferson County, Texas, you committed the third degree felony of obstruction or retaliation by committing assault in retaliation for or on account of the service of.
The judge wastes no time. Two separate indictments, both tied to the same day, March 30th, 2024. One involves assaulting a police officer, the other drug possession within 1,000 feet of a playground. That detail alone makes the drug charge far more serious. You can already feel the courtroom's tension rising.
Of the victim acting as a public servant, namely a Beaumont police officer. And then 24 CR 1818 is an indictment that was indicted, looks like about over 3 months later on August of last year.
It arises under the same circumstances.
And it also alleges on or about March 30th, 2024, you illegally possessed hydrocodone, and it's a state jail felony. It's also alleges that this was in 1,000 feet of a playground, namely Texas State Fair, located at Ford Park, 5115 IH10 South, Beaumont, Texas. And the third degree felony in obstruction or retaliation carries with it no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000, and a state jail felony with illegal possession of controlled substance carries with it no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can also be assessed. What's his bond code?
Here's where things get interesting. The defense wants bond, but the state pushes back, reminding the court that the defendant has already violated probation and even tested positive for THC while in custody. That's a huge red flag. Judges don't forget patterns like this.
Judge, you said it's at no bond at his last appearance, tested positive, and the court does not recall Mr. Harvey was quite disruptive in the court, and it took quite some time before we could get his result. And I believe, and I'm stating all that to remind Your Honor, because I believe that was one of the reasons.
I don't have a report in the file.
He might be waiting to be scanned, Judge.
What was the result?
I'm
He
looking
was
at it.
positive for THC, Judge, is my recollection. I was in trial in Orange County.
Hold on. I got it.
Oh, you got it?
Nice work coming to court. Investigated. That's good.
It's well in my office to have a stern discussion with him in the wake of this, outlining terms and conditions, making sure that he's a copy of the court's current terms and conditions, which detail and specify so THC related products that he signed. So I believe those were that those bond conditions were put in place in, I think, October of last year, if my recollection is right, but that are much more specific than they used to be. But nonetheless, we're asking the court to set some bond amount, and again, whether it's compliance with a drug patch or some other terms and conditions that will assure his compliance. I think Mr. Harvey's assured me that he will follow the terms and conditions going forward.
Judge, I've intended you a copy of the motion to revoke probation that's pending in its misdemeanor court.
Here's where things get interesting. The defense wants bond, but the state pushes back, reminding the court that the defendant has already violated probation and even tested positive for THC while in custody. That's a huge red flag. Judges don't forget patterns like this.
And the reason why I did that is because he was on probation at the time in which these offenses were alleged. And to me, it shows not only a pattern of not following rules, but definitely goes back to, unfortunately, Mr. Gertz wasn't here to see how his client acted today. He's representing, Mr. Gertz represents him on this.
Well,
So the state stands by the court's ruling and believes that a no bond is what's appropriate in this matter.
anything else?
No, Judge, like I said, that motion to revoke this probation is still pending. And the outcome of this case is going to dictate what happens with that motion. So, but again, we're asking for set. I believe his previous bond was $10,000 in these cases, if I'm not mistaken. We're asking the court to set a bond and bond conditions that are appropriate and that he can comply with it. And I hate to be, say this, and I'm sure there's an answer that I just don't know the answer to, but I know there are in Chapter 17, there are specific offenses for which the court can set no bond for violations of protective orders and bond conditions. I'm not under the impression, or at least I can't find a section that says the court can set no bond for a regular offense that's not delineated by the code. But I may be completely wrong about that. And if I am wrong about it, I'd love to know where that is. So I think
he's entitled to a bond under these circumstances, but it's not going to be an easy one. I would think. You've got on probation for not 6 months, and he's out for, by the way, unlawfully carrying a weapon, and so he's charged with two serious offenses of assaulting a public servant. Yeah. Oh, thank you very much. And illegal possession of you state have any particular amount?
The whole reason why I provided the motion to revoke probation deal is so that the court was aware that this man's already been given several opportunities to follow sets of rules. I don't know that there is a set of rules that we can give him to ensure that he's not going to either break the law or consume drugs of some kind. I mean, I see a pattern and I'm concerned. So I always will respect whatever the court decides.
All right. Anything else?
No, Judge.
Okay. Here's what we're going to do.
The hammer drops. A $50,000 bond on the retaliation case, $25,000 on the drug charge, and that's just the beginning. The judge slaps on a GPS monitor and mandatory drug patch testing. Translation? If this defendant even takes the wrong turn on the way to work, the court will know.
Third-degree felony, I'm going to set a bond of $50,000, plus the condition of, that's what I'm going to set in that one. We're going to have conditions on each of these bonds. $25,000 on the second bond, the second case, state jail felonies. And number one, you're gonna have to have a drug patch at all times as a condition of bond. It will test you. And you fail that test and you're gonna run out of bond opportunities. And also on this one, the obstruction or retaliation, knowing of where you are all the time. So you're gonna have a GPS device on you, so I know where you are. You're gonna have terms and conditions of probation, which
You mean bond, Judge?
bond, because they're gonna be similar to terms. I was thinking about terms of probation. You're not gonna just be able to amble about town. I want you at home, except work. You're working somewhere,
Yes, sir.
except work or school. Are you going to school somewhere?
No, sir.
Or medical needs
In my office too, please, Judge.
and to and from the lawyer's office. And if you have to leave the house to go to and from the lawyer, it's the most direct route possible. And the GPS will show it and we'll keep an eye on it. You have to know the most direct route and use it. And if it's medical, same way, to and from the most direct route. And work, same way, to and from.
Yes.
You've lost a lot of privileges because of the circumstances of these two offenses, plus you commit a crime while you're on probation for another offense. And that kind of you've punished yourself. Yeah, I'm certain that the misdemeanor people are going to wait on what happens here.
Yes, sir.
Did you need this back?
No, sir. I like the court being informed.
Right. Did we miss an I dotted or a T crossed?
Not in my opinion, Judge. Trial date shows to be December 8th at this stage, Jeff.
Where do you work, sir?
I work in Wayne Merida, job insurance,
And how much do you make an hour?
22.
Okay. Well, that's almost $50,000. How long have you been working there?
Well, yeah,
Okay. Well, so you were working there when this happened? Maybe not.
No, Judge.
Was this before?
This
Did
was
you get a job after all of this?
this is.
This is a powerful moment. The judge reminds him that a felony conviction is like carrying a dead weight for life, stripping away opportunities, rights, and respect. Judges often use these speeches as both a warning and a last chance for redemption. But will it stick?
Well, that's a lot of money that you'd lose if you go to prison, probably. And you got a lot to lose by committing crimes. It has consequences. Some consequences are forever. You carry that around forever. A conviction, felony conviction, you'll carry it around like carrying around a body. It's just wears you down. You lose opportunities, and rights and privileges.
That's why.
And I don't understand. You don't think, of course, I'm sensitive about presumption of innocence. I'm intimately familiar with that, and I believe that. But why would anybody, it's a rhetorical question, why would anybody think assaulting an officer or a police officer is would be a benefit in any way to you? And while and then the drug thing, and then you're carrying around drugs. And that's foolish.
I understand that. Thank you.
Where'd you get your drugs from? That's rhetorical. See, he says, don't answer. Why do you think he said that? Because he knows it's wrong too. We all know it's wrong. But you know it's wrong. Illegal drugs are wrong. So just put some A lady in jail this morning.
Notice how personal the judge gets here, talking about parents, discipline, mistakes, and consequences. This isn't just legal talk, it's moral accountability. The judge is practically begging him to choose a better path, while still holding him firmly responsible.
For testing positive for drugs. But mistakes have consequences. You have parents, right?
Yes.
Were they good parents?
Yes.
Did they teach you that mistakes have consequences? You pay for mistakes. You do well, you get rewarded. That's right. You do well, you get rewarded. If you make a mistake, you're going to get your hand slapped. Or your rear ends swat. Somebody's going to spank you. But why do we do that? That's because we want people to make the right choices. And those are three bad choices that they're talking about here. Okay, fix that.
Thank you, Judge.
Can you?
Yes,
Can you
sir.
fix it?
Yes, sir.
All right. Yeah, that's some people come up here and they're not capable. There's no hope. I think you know better. You do. You're able. That's what's frustrating about it. You know what the right thing is. Do it. It's so much easier for you, your family, everybody you touch in life. You want to make proud of your actions. You got to do that one step at a time, every day in the right direction. That's success. Okay,
Yes,
do
sir.
it. Oh, anything else?
And there you have it, 2 serious cases, a history of violations, and now strict bond conditions that will either keep him in line or land him back in custody. What do you think? Did the judge strike the right balance between fairness and protection? Drop your thoughts in the comments, and don't forget to subscribe for more real courtroom breakdowns like this one.